Well, good morning, everyone. Thank you for joining us for the third of 5 webinars. Obviously, at Flirting Hood, we love alliteration. So we had unfair labor practices, webinar 1, unemployment number 2, and now it's the update. So I'm joining you virtually, at least, from the lovely banks of the Cannon River in Northfield, Minnesota. So what is today's topic is public labor and employment law update. So thank you to the Minnesota legislature. We got gobs to talk about, and gobs that are going to be effectuated starting July 1st or August 1st. So my name is Brandon Fitzsimmons, a shareholder and labor and employment attorney with the firm. I head up the firm's labor, employment, and HR practice area. So today, if you have any questions, we'd like you to utilize at the bottom or top of your screen the Q&A function. So I will try to peek at those as we're presenting, or even if you have specific comments, I will try to address those throughout the webinar and especially at the conclusion of it. So here we go. What's our agenda for today? So first and primarily, we will talk about Minnesota new laws. Secondly, we'll talk about some federal issues, what's happening, especially at the state agency level. What are some of the Biden initiatives? Now, what we're not going to talk about in that topic is what's happening with Congress because they're in stalemates and nothing's going to get done. I'll throw it out there practically for the next couple of years employment-wise. We'll talk briefly about what's happening with labor contract grievances, and then especially based on these gobs of new Minnesota laws, what are recommendations how all of you at the public employer front end can try to implement a lot of the technical details. So here we go. I think the PowerPoint stock image photo of a fox in distress demonstrates what happened this session. So what are we talking about now? Minnesota new laws, or as we've called it, for those growing up in the 80s and 90s, employment law palooza. So here we go. So kick up your feet. Don't grab a drink yet. You're in the workplace. Wait for the weekend. But we've got lots to talk about in this session. So I will say this, 2 things about mechanically. Here's what we thought about. One, this is an extensive and exhaustive list of what happened with labor employment law just this past session. Now, keep in mind to give us some credit, they did not end session as they constitutionally were mandated to until late May. So from our end, yep, it's complete, it's accurate, but there may be more technical details that we'll follow up in writing when we do our usual legislative summary. So the only 2 demarcations or categories that we'll talk about are 1, labor laws, and 2, employment laws. And I will say the other things about the slides, though it defies, I get PowerPoint best practices, we try to be pretty detailed and technical in these slides. Why is that? Some of these laws, you're literally going to have to figure out how to implement within 16 days. Following the session, that's July 1st. Now, thankfully, most of these laws are the usual default effective date of August 1st, but we want to give you the tools that not only during this presentation, but also to utilize this PowerPoint, which will be available and accessible to all of you to help you implement. So now, here we go with that said. First, let's talk about PERB. Now, obviously, Nico presented last week on unfair labor practice in the PERB board. So this is a regurgitation of that slide. So the bottom line is the legislature finally has fully funded and legally made effect the Public Employment Labor Relations Board, who will now have jurisdiction over unfair labor practice claims under Minnesota's Public Employment Labor Relations Act through an investigation and administrative hearing process. So this board will be able to investigate and have hearings on unfair labor practice charges. And 4th bullet, they also have the authority to issue complaints and pursue enforcement or remedies. So the biggest thing they got was annual funding over the biennium, which will equate to $1.5 million. So what we do know practically, we're already hearing buzz and we already seen from the unions that they are going to utilize this as leverage to not only get what they want, but also as leverage potentially for the negotiation process and or thirdly, potentially leverage through also piling on grievances against employers. So again, we don't want to be too hyperbolic about it, but here we go. Coming July 1st, a lot of you are going to now have to deal with unfair labor practice claims, which for some of you may practically and thankfully been a foreign word, but we will default to Nico presentation, or another labor employment attorney in the office. His presentation, for those who weren't on it, is available online. So I do recommend you listening to that hour presentation. So one, they effectuated PERB. Two, they had an extensive law that we're not going to spend too much time on, but basically providing a lot of the non-public data you give the board through the investigation hearing process will remain non-public if it was. But by the way, if you go to hearing, much like a district court or administrative hearing, generally a lot of it will be public once it's admitted. So again, good for you to know, but we don't want to spend too much time in the weeds on that. Now let's get to things that will impact you directly at the negotiating table this session. So the legislature made two changes that overlap to PELRA, the Public Employment Labor Relations Act. So effective August 1st, when all of us are going to get into fall negotiating season for 24 contracts onward, one, what did they do? They added, quote, staffing ratios as a term or condition of employment that a public employer is required to meet and negotiate with unions over. So I'm just going to pause on that one bullet point. Here's what happened. Obviously, you had Minnesota Nurses Association, strong lobby. They had their own law. They took principally lobbying that happened with that law and said, well, by the way, let's apply it to the public employment sector because we also have, some of you have healthcare staff. Let's add the word staffing ratio as a bargaining issue. Now, that word is ratio is very important. Now, put aside the second bullet, which added confusion in the legislature's infinite wisdom. They mentioned the word ratio. So just so you know, here's our interpretation without any legislative history scouring yet, or clearly no, the law's not in effect, or court or administrative interpretation or arbitrator interpretation of this. We're hanging our hat on the word ratio. This does not mean directly that we have to negotiate the number of staff, or some of you call it the minimum person or manning or personnel standard, for example, in fire departments, you hear a lot about. Instead, it says the word ratio. Now, here's the problem. What exactly do they mean by ratio for those not in the healthcare sector, for those not in the local government sector? Clearly, or excuse me, school sector. School sector, clearly it's it's the ratio of teachers or staff to students. Clearly in the nursing, it's the ratio of patients to staff. For most of us, a lot of the local government, we really don't frame things as ratios. So full circle, don't talk about ratios. A lot of you don't talk ratios, and we're not interpreting this to mean what your minimum manning or number of staff is. But then the legislature now added confusion. Add this to unfair labor practice 1, what interpretation is going to win the day? I'm not trying to be too flip. I think we're going to see a union push this issue. If we say no, it's not negotiable. What did they do? They removed, quote, the number of personnel as something that was otherwise, quote, an inherent management policy, where the legislature expressly says things that you're not required to meet and negotiate with over. So where's our legal la land? On one hand, we can't expressly say under PELRA number of personnel is not negotiable. On the other hand, the number of personnel is not expressly something we have to negotiate over. So what did the legislature do? Toss up. We are concerned about number of personnel now being removed as a inherent managerial policy. We can't expressly tell you and unequivocally tell you, yeah, it's something you have to meet and negotiate over. But here's the problem. We're going to have to nuance our advice. Legally, conservatively, you can interpret what the legislature did to mean we got to negotiate number of personnel. Legally, moderate to aggressively, well, no, we only have to negotiate staffing ratios. But we're going to end this with saying, let's make sure we're not talking number of personnel in our contracts. Then what can we do? Then we can argue, well, by the way, even if number of personnel is something that is no longer an inherent managerial policy, we either say it is in our management rights clause, or we're silent in our contract, therefore it's not negotiable. So big thing is, a lot of you under old PELRA had number of personnel as a management right. That still stays regardless of what the legislature did. So do your audit and let's update your contracts if we don't have number of personnel. So I did want to highlight this. This is something that's going to impact you right away in the fall with negotiations. All right, now we shift to, I do want to give a little context to a lot of these laws now we're going through. What was the playbook? What were the dynamics this year? One, you had a DFL controlled House and Senate. Two, you had a DFL governor. Three, you had a presidential administration who is supporting similar things that you saw the legislature pass this session with the political dynamics they had. Then four, the unions and the private sector have had mixed results trying to get the National Labor Relations Board to either implement new rules or through their unfair labor practice process, try to get certain fixes in the law. And the unions at the federal level, both administratively through regulations or policy and through unfair labor practice claims, had mixed results. So what the Minnesota legislature do is say, well, we're just going to give it to you through law. So that's what they did. So that's a lot of these laws are practically a copy and paste from what's happening at the federal level. So let's talk about now labor union formation effective August 1st. This bottom line, this has been happening at the federal level for years, this discussion is what they wanted to do is if under that first bullet point, obviously when you form a union, a labor union with a specific employer needs to have cards signed by at least 30% of the employees in the relevant unit. Now the legislature expanded that a little bit to say, well, by the way, in what's called the card check process, if 50% or more of the employees, first bullet point, in the proposed unit to form a union at that employer, sign those cards, BMS will investigate, as they always do. This is right out of the law. Then if BMS says over 50% of the employees in the unit said they want in the unit will be formed and you will have a new union at the public employer. Previously, you as the employer could either say, yeah, fine, we're good with those card checks. If 50% or more signed off, fine, the union can have it. A lot of you as public employers said, well, fine, even regardless of the number of cards signed, we want to have the election that was your right as a public employer to ask for. Now, if a majority of the employees say we want in the union will happen and there will be no election. So even if 51% we want in, 49% said no, you can't even have the election. You will just have a union formed within you as the public employer. And then further, still all related to this law, this reference, hey, by the way, with those cards, if they're signed electronically, they're valid, which was not in the law, specifies that if, for example, an employer commits an unfair labor practice, BMS say, let's have a redo. And then it repealed the law, interestingly, that talked about the employer and union could have a joint request to form a union if over 50% of the employees say they want in. Why'd they get rid of that law? Because they want to make it easier and let the union unilaterally control whether or not they'd be able to unionize. So that's why they got rid of the joint request issue. So full circle, you may get more bargaining units as a result of this because the process is expedited and a lot easier for unions to form. Now we talk about union dues. This is uber technical. So if you're the HR person or payroll person on these webinars, you should scour these next slides. I'm not going to spend too much time talking about the details, but here's the deal. What do they want to do post Janus? Janus was the U.S. Supreme Court case that said unions can't force public employees who don't consent to payroll deduction for dues to pay dues. But what did the legislature want to do? They wanted to make it easier for the union's employee, especially the unions, to collect payroll dues from employees. So here's where it gets really nuanced. And technically now, we've advised gobs of public employers on this. Our advice will now change effective August 1st. And what do we mean by that? Is previously, we really obsessed about you can't deduct union dues from an employee unless and until they had a nice little card where they sign with their consent saying, I want union dues withdrawn. Instead, now, based on the second bullet point under law, under PELRA, we don't need that card per the legislature. Now, I think this one may be challenged based on Janus, but let's put that aside. Now, you have to rely on if the union, Law Enforcement Labor Services, asks me, says, by the way, we union are certifying that employees X, Y, and Z. I mean, I know you all get the list, but usually we wait till we have an individual card. Now the individual cards aren't required. So as long as the union tells you an employee consented, we have to accept what the union says. Now, they try to get rigid and technical in the law, which is why this spills over into 2 or 3 slides. But the bottom line, if you get a union certification, say employee said they want union dues deducted, you have to accept that, and you don't have to go to the employee and say, where's your card that you authorize union dues to be deducted. So this causes a little angst, but you should still do your due diligence, make sure they sufficiently certify it. And then, even the legislature even went further in second bullet, second sub bullet, that said the union, we can't require as public employers that the union provide us a copy of the authorization. So you see, our whole advice now is just, it has to be brand new. We can't even ask the union for the card where sometimes you get an employee saying, why are they deducting my dues, or I want the dues yanked. Well, now the union gets to completely control that. And the gist of the law, you just have to trust the union. Okay, well, it's what the law says. So if the union certifies it, we can rely on it, even if the employee raises a stink. Your question's gonna, or your redirection for the employee says, I don't know, per this new law, you're just gonna have to talk to the union about it because they certified you want it deducted. So take it up for them, with them. Now, the next slide, of course, made it tougher for an employee to yank those dues that they maybe previously authorized. It says a dues deduction authorization remains in effect until the employer receives notice from the union that employees change or cancel their authorization. So what was the old way? The employee signed a card, said, I want dues deducted. The last part of the card would say something to the fact, by the way, I have to have dues deducted until I state in writing I no longer consent to it. Now, again, similarly, that law, that technical advice is out the window. You just sit back. So if the employee says, I don't want union dues deducted, HR, you say, no, you're based on the second slide. Again, you have to say, sorry, union says you want a dues deducted. If you want it yanked, you got to go to the union. And by the way, we can't stop dues being deducted till the union tells us. So full circle, union has unfettered control over union dues now, instead of some employer-employee discussion and card. So again, HR payroll ramp up for this come August 1st, your process is going to change. All right. And then again, this law was so extensive, but we have a third slide on what was in the law. And they just clarified whether or not they want dues deducted as independent of their membership. It requires you need to know the moment the union says employees X is dues should be deducted, you got to start doing that within 30 days or you'll be trouble under PELRA. Then if there's any dispute between employer, employee, and or union over this, of course, add this to the gravy train of what's going to happen with PERB. They can take it up through an unfair labor practice claim through PERB. So again, add that to the list of liability exposure through the PERB ELP process for public employers. Phew. Okay. So now we've shifted from PERB to what's negotiable to union dues to union formation, because that wasn't enough. Now let's talk about what data unions are entitled to. So now under law, again, we dealt with a lot of public employers, all of you on this, especially during grievances, is the old law was if a union said, we want personnel data because we're trying to represent an employee in a grievance who is disciplined, we'd usually say, no, pick it up with BMS. Now the law has flipped, but work with us here. We got to be customized. It can't be too liberal with this. Now the law says the union, basically unfettered, has a right, if they file a grievance on the second bullet point, to get any personnel data on what we're going to argue is just the subject employee. So we had discretion before to give it to them. Now we have to, or again, add this to the list of things you may get dinged on for an unfair labor practice. As a side note, I work with a public employer. We already have the union pushing this. They discipline an employee. Union saying, oh, by the way, we want it. We're saying, well, no, it's confidential and we got personnel data. You don't get any of it, take it out with BMS. And they've already thrown this law in our face saying, well, the law is amended, you need to give it to us. So now we're saying, well, no, you got to wait till August 1st. Pre-August 1st, you don't get it. But yeah, August 1st, now this union asking for it, they're going to get it. Now, we do want to get really nuanced on the advice on this. This just references personnel data. Now, we're going to narrowly interpret that they only get personnel data to the extent it impacts the subject employee, for example, of a grievance. That does not mean they get personnel data on, for example, other employees who may have complained about that employee who was disciplined during the investigation. So just, add this to the list of things we're going to sort through with all of you as public employers on a case-by-case basis, work with legal counsel, especially as we start implementing this law on, all right, what exactly, whose personnel data does the union get? So again, we know we'll have to get technical. We already are with the Data Practices Act, but this is going to add just one more layer and one more billy club the unions will have over you, especially during a grievance. But be careful, you also can get sued if you give too much personnel data on an employee who's not the subject. So darned if you do, darned if you don't. But this is going to be a very technical law that you're going to have to work with legal counsel on to figure out what precisely the union gets. So this will add this to another reason why all of you are going to have to ramp up with HR and payroll. This administratively is going to take a lot of time for all of you to implement. Now, again, you're right. If you haven't had a grievance, don't worry about it. But if you've disciplined union employees, you're ripe for a grievance, and you're going to have to deal with this right away in a grievance process. So beyond, the legislature said, well, that's not quite enough here. Beyond giving the unions entitlement to personnel data, they also said, and we dealt with a lot of you on this one, they also have a right to certain personal data, not personnel. Whew. Okay, so this is one you should all ramp up for over the summer. Come up with your checklist. We'll talk about recommendations. But within, what do you have to do now? Let's first talk about new hires. Within 20 days from the date you hire an employee who's clearly in a bargaining unit. Now, thankfully, the legislature said we have to put this in Excel file format. So we can't even use our customized human resource information system package. We specifically have to give them an Excel spreadsheet. So good job, legislature. What happens in 10 years when no one uses Excel? All right, put that aside. You're stuck with it. You got to create an Excel file. Or, by the way, we have to meet and negotiate with the union over what format it should be in. Okay, good start. What do you have to give within 20 days? Name of the employee, job title, worksite location, home address, work telephone number, home personal cell phone numbers, date of hire, work email address. Now, what's important here? Update your applications when you give the Tennyson warning, when you talk to employees about, all right, where may your data go, like your home address, because this gets employees riled up. You're going to have to add to the list of people who may get that is the bargaining unit. So a lot of you had it. We drafted perfunctorily, but update your application Tennyson warnings to make sure we're telling employees, by the way, yep, this stuff may end up in the union's hands, even if you didn't want it to. Under law, we have to. Okay, so now that's new hires. Now let's talk about current employees. Effective 1/1, now the law takes effect August 1st, but this next one doesn't happen until 1/1/24. So add this to the HR payroll checklist. Every 120 calendar days, okay, starting 1/1/24, for every single bargaining unit employee in an Excel file again, that we have to meet and negotiate if we want to give them something other than Excel file, we have to give the following name, job titles, home address, work telephone number, home and personal cell phone numbers, date of hire, work email address, and personal email addresses. We have to firmly give that to the union. So as a side note, beyond Tennyson's and applications, you're going to have to communicate to bargaining unit employees, because we all know it. You have certain bargaining units. You have those few dissenters who want nothing to do with the union, but they're stuck in the bargaining unit. So I want to get real technical. This is not just union members who authorize dues deduction. This is every single employee. Even if they want nothing to do with the union, if they're covered by the contract and in the unit, you have to firmly hand all of this over to the unions. Now, what's the deal with this? Here's the problem. You can't control, as a side note, the law was silent. The unions can do whatever they want with personal cell phone numbers, work email addresses that you have. So again, that's why we got to be cognizant in your Tennyson warnings. Let employees know, by the way, here's why we collected it. The union can get it. And by the way, once the union gets it, they can do whatever they want. For organizing purposes, membership purposes, political purposes, they can do whatever they want with it. So that's a side note that the law is silent. All right, third thing is, for separating employees, we have to tell the union within 20 days that employees separated employment. So we got to have an automated process. We got to have a checklist, and you're going to have to give this all to the unions. So one question came up talking about seasonal or part-time employees. So here's the law with that. This only applies to bargaining unit employees who are public employees you've determined are in the unit. So the question was, well, was there any law that talked about if we have an employee who goes over 67 days, becomes a public employee? All these law changes had nothing to do with that. So this has nothing to do with who's in a bargaining unit. This has nothing to do with who's a union member. This has nothing to do directly with who exactly we have to give information on. So the bottom line is who you determine is a union member or in a bargaining unit is only based on current law. So don't worry about, does this change? We always get that employee works a 68th day. Do we have to tell the union they're in the unit? No, these law changes have nothing to do with that. So this is just who you have determined, and the law is determined is already in the unit. So there's the technical weeds on that. Now we'll shift to next slide. Okay, beyond giving the union entitlement to data, beyond giving the union entitlement for us to collect dues, the law also said, again, all this is based on federal and NLRB contested cases. Running out of breath on all these changes, but here we go. We now have to give, as public employers, union certain right to access your facility. So, okay, here we go. What does this mean? If you have new employees who are in the unit, so I want to clarify, this only applies to people you've determined and the law says are in the bargaining unit. We have to allow the union to meet in person with that employee. It doesn't matter if the employee says, I want nothing to do with it. Sorry, the law says we have to give the union right. So the employee can meet with the union and chat with them. Again, you got to love the details of this law for 30 minutes within 30 calendar days from the date of hire. Now, and when specifically do they have a right to do this? It's either during new employee orientations. Okay, that's a very technical word. What if we call it something different? Or if the employer does not conduct new employee orientations at individual or group meetings. Okay, legislature didn't find, what are you really talking about? So here's the deal. If the union says we want our 30 minutes within 30 calendar days of the hire, you either tell them, here's when you need to do it. Here's our employee orientation date. Generally, you don't want, that may not be advisable. Let's call it something different. Or if you say you don't conduct something technically called an orientation, you just say, all right, you rely on the union to ask you. So here's the deal. We don't have to firmly tell the unions, except, let's add it, except unless you have an orientation. So full circle, if you don't do something technically called an orientation, you just let the union tell you. But if you do have orientation, first bullet point, second sub-bullet point, you have to provide the union with no less than 10-day notice of advance of that employee orientation. Except, now the law, gets in the weeds and we got to do it. You're going to be subject to an unfair labor practice, unless we can claim, well, you didn't get 10-day notice because there's an urgent need critical to the operation of the employer, not reasonably foreseeable why we couldn't do it. So here is where the confusion is. The day you hire an employee or they start, you want to have orientation starting day one. So then you were scratching our head. How can we give 10-day notice when we start our orientation day one? Because that's a best employment practice. Sorry, team legal needs to get through the technical details, but here's the deal. Here's unfortunately what you might have to do. If you start an employee in orientation day one with the employee, well, best practices in anyways. Unfortunately, I think the law may be construed as we need to get ahead of the start date of employment with the union and tell them, by the way, we're giving you information we're required to. Here's the new employee and their start date, under the previous slide. Oh, and by the way, they start on date X, and that's where orientation starts. So just so you know, here's when you can do that. So I don't know if the law is silent on that, but unfortunately, that may be our technical read on that. So again, all this takes place August 1st, so at least we have a month and a half to sort that out. Then we got to give notice of who attended employee orientations, really, but okay, we do. And then the union meetings, the last bullet said they can be held virtually or longer than 30 minutes if we agree. So full circle, the union's going to have to tell you about that. You're going to have to approve it. So, I mean, I don't want to be too flip, but all these words that are in the slide are in the law. So we got to deal with it and we got to implement it. But administratively, this can be a lot on all of you to administer it. So one question came up about employee cell phone numbers. They talk about, well, what if the public works supervisor, for example, has it, HR doesn't? Sorry, not a good practice. We got to have HR, for those who don't have it, whatever utilizing as HR administration, get because here's the deal. I first say, well, if your public works supervisor got their cell phone and asked for it, then we give a tennyson warning. Normally that doesn't happen, like it's for an on-call list. So here's the deal. This really cements why we got to have HR be the gatekeepers. And every time we ask an employee for their cell phone number, let's make sure we give a tennyson through HR. So that is going to be a problem. We are going to have to scour that law because it references if the public employer has their cell phone number. So unfortunately, if your public works supervisor has it, they're really technical part of the public employer. So there's an argument the union gets it. And then, two administrative notes. To ask, you will get a copy of these slides. We will make them available online shortly after, and a recording of this webinar. So yes, those are forthcoming. So all right, so we dusted off those questions. Okay, so let's add more access to facilities. For current, now we talk new employees, what's the second part of the law? Now, thankfully, the legislature, no one decided to take this off team legal. Now, here's where I'm going with this. They said for bargaining unit, quote, members, the union gets certain access. Now, just so you know, literally the word member means this, is somebody who's actually paying union dues and the union says is a member. It is not construed to be people, other bargaining unit employees are not members. So I'll be blunt. I don't think the legislature intended to be this narrow, but I got to tell you, that's how they drafted it. So for employees who are in a unit, and secondly, they've said, I am a union member through likely signing the dues card, this next law applies. It does not apply technically under how the legislature drafted this to people who are not members. So what can they do for quote bargaining union members? They can communicate with members using employer issued email addresses regarding certain topics only. Okay, good luck babysitting this one. Collective bargaining, administration of collective bargaining agreements, the investigation of grievances, other workplace related complaints and issues, and internal matters involving the governance of business of the union. But it also says it must be consistent with employer generally applicable technology use policies. So here's the deal. We're going to have to revise our template personnel policies, and I'm sure the League of Minnesota Cities and others, Association of Minnesota Counties, will be on this as well. We're going to have to do a peek sees at our technology use policies and determine how do we draft this? Because a lot of you say, well, you can do non-public employment stuff incidentally. So is that enough to say that? Or a union's going to claim, no, they get to do a little more than that because Pelwer said we get to email them and they get to email us back on these 4 topics: collective bargaining, administration of agreements, investigation of grievances, other workplace issues, and actually 5, and internal matters involving governance of the union. So this one's tricky. So bottom line, we can't sanction an employee for using, now, just as a side note, I want to be real practical, and practical discussions are okay. You got to advise employees, really. You really want to be using your public employee, your city, your county, your state, other government entity account to do union business when our IT department has access to all of it. I mean, you first sometimes going to have practical discussions saying, yep, it's your right. Leave it at that, but let's talk practical realities. But let's say they do use it. We're going to have to be, again, look at our policies, and it's going to be this bottom line, this will make it more difficult for us to say, oh, hey, what do you know, where are we going to draw the line? Hey, we caught wind or we got a complaint. You've been spending hours and hours administering union business with your email account. Now we get these, we've dealt with this one, gone all the way to arbitration on them with mixed results. So now the scouring for us is, well, is this really a carte blanche right to do practically, they can expend whatever time they want doing it? Or do we rely on the second part of the law that says, well, the technology use policy said it can only be incidental. So on the other hand, they're going to say, well, no, this gives us an inherent right that can be more than incidental. So I don't want to, I'm giving you great advice because this is really a gray law, but I do think it'll be a big deal, and it's going to be tougher for you, bottom line, to enforce your technology use policies that say you're spending too much time on union business. Where's the line going to be? Well, I guess we're going to let PERB now probably sort that out, or let arbitrators sort this issue out. So add this to the list of things that'll cause you more angst on what you can do about it. Okay, we're back to union access. Beyond emails, the law also went further and allowed union to meet with, again, just members, not bargaining unit employees who are not members, at facilities owned or leased by the public employer regarding the same topics, collective bargaining, administration of agreements, ... Now, they also added some caveats. So, okay, caveats are good, but now more gray things we have to interpret. The use of the union to meet with their members can't interfere with operations. The union has to comply with security protocols. The meetings conducted in government buildings must not be for political purposes. Then the last bullet point is we can charge them for maintenance, security, and other costs like anybody else. Now, here's the problem with this law. They did not put a time constraint on it. Okay, so what are we going to rely on when it says use cannot interfere with operations? Here's how we are going to interpret it, though I got to tell you, this could be challenged. When it says it can't interfere with operations, we're saying this. Bottom line, it can't be during normal working hours, but yep, during the half-hour lunch break a lot of your employees get, you can meet with them, but otherwise you can't meet with them during the workday. I do think that interpretation might be challenged, but here's the problem. The moment a public employer says, okay, fine, you can take that half hour to meet with them from 9:30 to 10 during the normal workday, you've now set a precedence, and I don't think that's a precedence you want to set. So I hate to say it, somebody on this webinar among the nearly 100 participants is probably going to have to be a lab rat here for when we tell a union you can't meet during normal working hours, just to see how PERB and arbitrary, or well, it'd actually be PERB if it's an issue of law, is going to sort this out. But I'm sorry, we got to be technical here. We likely are going to advise employers, well, don't open up that door to allow them to meet during normal working hours. Okay, as if you're not concerned enough with trying to implement all this by August 1st. Let's keep going. Actually, we're done going. So thankfully, everyone give applause. We're done talking about specific labor union laws, but here's the deal. Well, we're going to end with recommendations, how you're going to implement all this at the end of the presentation. So, maybe we can take a 1-minute breather if anybody wants to provide some Q&As. Otherwise, we will keep on going with this. Okay. So I'm not seeing any questions pop up. Now let's move on to what we've categorized as employment laws, but that's a pretty liberal word. So first one is, especially for upper level management, the legislature finally has repealed the law in which, the previous law, so here's the law that's out the window. It provided that the salary and the value of all other forms of compensation of a person employed by a government entity was limited to 100% of the salary of the governor. That law's out. So on one hand, you interpret it, good, we're off, we can pay our upper level management whatever we want. Except obviously, what didn't this law do? It didn't talk about, well, by the way, you can deviate from the pay equity law to do it. So this is a big deal. I know we dealt with this doing our job classification and compensation studies. We'll talk about that a tickler within our 5th webinar at the end of June on some best practices and trends in compensation. So this is good. This is a big deal for management. However, we still are going to have to comply with the pay equity law. And we're still going to recommend, well, let's still pay our folks within the base pay structure. As a side note, for all of you we've done class comp studies for, we set up structures that actually had wages that were higher than the base, higher than this cap. And here's the reason we did it, just in case the legislature opened up the door to actually utilize those higher numbers. Now we can, but hey, yeah, let's still comply with the pay equity law. Let's still comply with our base pay structure, but now we can use those higher numbers that legally we otherwise couldn't. So big deal. Now, this law is effective right now. So all of you are budgeting, a lot of you are managers. I know that's slippery, but let's talk about this in the budgeting for especially 2024, what we want to do with some upper level management, or it may be just one of you within who is limited by this. So big deal, heavy lobbying, especially by municipal utilities on this one and counties. Okay, here we go. Next big one, earned sick and safe leave. So what did we do? We put in effective dates at the top here, the header of all these. So this one's effective 1/1/24. So start bracing now. And again, add this to your checklist of dozens of policies you're gonna have to look at. So what did the law say? So this is comparable to the Minneapolis and St. Paul sick and safe leave ordinances, but now it is statewide. So what does this mean? Now, a lot of you are already complying with it without even preparing or having this law in effect. So what do we mean by that? Employees will be entitled to accrue 1 hour sick leave and safe leave for every 30 hours worked. Now, this is a side note. This is going to cause absolute wonkiness for those who have paid time off programs. So that is something we are going to work with technical advice on. Well, hang on. We got rid of our vacation sick leave. Oh gosh, now what do we do? But let's put that one aside. Those going to be important for those. A lot of you have PTO. What do we have to do? So they get 1 hour sick and safe leave. They're just entitled up to 48 hours, but obviously anybody who has sick leave, traditional sick leave, your cap is probably likely well above that, because usually they'll accrue like 8 hours a month, 96 hours a year. So that likely won't be a big deal, but that's just an entitlement. Now we're going to talk about what employees we're talking about, but hang on that one. They also are able to carry accrued hours. So we no longer can have that forfeiture that if you haven't used sick leave, it's forfeited at the end of the year. I know that's rare for a lot of you for sick leave, but yep, some of you still have that out there. However, they can have no more than 80 hours in their bank. So what you could do though is front load at the beginning of the year, 80 hours of sick and safe leave at the beginning of each year. So again, a lot of you are just complying with this without ever having braced for it. And I will say this, I did gloss over the big nuance here, is that employees get 1 hour for every 30 hours worked. So I want to go back to that first bullet point. So that causes wonkiness for your 40-hour a week employees, that really what they get to do is, you can do the math. That really means every 3 weeks they're earning 3 hours. What do I mean by that? Is instead of earning 8 hours every week, they get to earn 8 hours, 4 hours. Botch up my time frame. Let me do a redo. They get to earn 4 hours every 3 weeks based on this. So it's not an hour every week. It's an hour accrued for every 30 hours worked. So where is it? Now, what can they use the sick leave time for? Now, a lot of you already had policies and contract provisions in place to address this, but here's the deal. There was the current sick leave law that says for current sick leave hours that you give, though you're not legally required to, here are the family members you can care for to use it. Now, what did the legislature do? They expanded it and used some of that language in the existing law, but they went beyond that for what these legally entitled hours can be used for. So what is this? Here's our problem that, as you can tell, we're still sorting through. Do we need 2 hoppers of legally entitled hours versus practically how many hours do we give them? And that way we have 2 separate laws. We got one bank says, here are your legal core hours and what you can use the absences for on this. And we have a separate bank that is more expansive than the legally entitled hours that we don't have to apply this specific slide to for what they can use it for, but still have it subject to that other existing law that talks about family members. So side note, we're still working on this one. Thankfully, yep, you're gonna have to amend policy soon, but thankfully this is a 1/1/24 one. So we are still sorting out, do we have a legal sick leave bank, and do we have a other entitled sick leave bank that's not law? We'll figure that out. We're going to give targeted advice. But full circle to the legally entitled hours, there's an expansive list of what folks can use it for. So for example, one that may be newer to you, but obviously COVID was a trigger for it, is fourth bullet point, that employee can't work or telework because due to health concerns related to potential transmission of a communicable illness. They now can use their legal sick leave hours for that. But then they didn't amend the other law that talks about, well, what about non-legal hours? So for the non-legal sick leave hours, the law is silent. For the legal sick leave hours, they can use it due to these concerns. Okay, we got things to sort out, but as you can tell, we'll give targeted advice on that. Bottom line, it's an expansive list of what they can use these sick leave hours for. Then they also talked about who a family member is that is comparable to the existing law that you're all used to dealing with. So we've got some questions flying in. So we'll do a little side note. Can we prorate the 40 hours on new hires? There is no proration. The law has already prorated it. What do I mean by that? The law is this, is that you accrue for every 30 hours worked. We don't care if you're full-time, you're part-time, when you started, it's just every 30 hours you log in, you get 1 hour. That's simple math. So full circle, I want to be clear, this does not take effect till 1/1/24. So someone brought up a question, because there's no proration. Here's the deal. I want to be way clear here. Starting 1/1/24, that you start with, they get 0 hours. They only get an hour once they've worked 30 starting 1/1/24. So there's no front loading. You can front load, but you don't have to. Then we talked about, another question came in on PTO. Okay, I got to be blunt. We did not have time to scour the law and go, great, how do you do it if you don't have traditional sick leave? Do you have to have a PTO bank plus a sick leave bank? Can we credit them for sick leave hours within the PTO bank? I'm sorry, that is a question that we will give targeted follow-up advice to. And another question was, is this for all employees, including part-time and seasonals? So full circle, based on that, as the law was drafted, but this is one more scouring, and I know it's a big deal to all of you, so this is part of our follow-up. The law referenced employees liberally and employees for every 30 hours worked. So yeah, unfortunately, that likely is going to be construed that we don't care if you're part-time, if you're seasonal, how many hours overall you've worked, unlike other laws. Bottom line, if you're the 16-year-old lifeguard working at the pool, likely this law does apply to that person for every 30 hours they work. So we're 90% there, but that is part of our final scouring we will do to clarify about that. But yes, likely it's going to apply to every single employee working for you for every 30 hours worked. So the gist is, this is the legislature saying, we don't care who you are, every employee's entitled it and might get sick and should be paid, even if they've only logged in 30 hours for you, the 31st hour they want to use as sick leave. So as drafted, that's our interpretation right now, but we're 90% there and we'll scour it. So they did talk about who family members are within this law. So another question came to be, do we need to pay out sick and safe leave? And I believe that is on the next slide. So I do want to talk about the PTO thing as well. So full circle, the law does not entitle employees to get severance or to get it cashed out. So as drafted, you don't have to do that. Now, I do apologize. I do want to jump to the PTO thing because I got to get ahead of myself with the advice here. So, but I still want to clarify, this is really getting very nuanced. Is if you have paid time off policies, your policies in of themselves may already satisfy the requirements if you meet the accrual and usage requirements. So if you have PTO and you have no traditional vacation sick, how would you comply with the law? If your PTO policy provides that at a minimum, one, you earn a PTO hour for every 30 hours worked, you're going to meet the accrual provision of the law. And, excuse me, if it entitles you to carry up to 40 hours of PTO every year, it'll also comply with the law. So again, I'm back to, we're still going to have to look at your PTO policies. So here's what we know. You still don't have to go to traditional vacation sick if you have PTO. But we now have to scour within your PTO. We're back to, are those legal sick leave hours? You're going to have to still differentiate legal sick leave hours, I think, within your PTO policy versus when they're not legal, because if you don't demarcate, your employees can start to use sick leave hours, if we're too liberal in how we classify things, as non-legal hours and lump them all in one bank. Now they can take sick leave for all these things that are probably not in your policy, like the telework one, if they have concerns about communicable illness. A lot of you don't have PTO or sick leave policies that says you can use sick leave for that. So if you don't differentiate legal versus other sick leave hours, here's the problem. There's an argument they can use other sick leave, non-legal hours due to these concerns. Now, maybe you're good with that. So what does this mean for all of you? Obsess about drafting the policy to clarify all this. That'll force you to think, what is our policy? What's our philosophy? Put it in writing, and that's going to help clarify how you're going to administer the law instead of just trying to scramble determine. So bottom line, really get to your policies here to figure that out. Now, other people brought up things like, well, what about ambulance and fire? Here's the deal. If they're an employee, the law is drafted said, if you log in 30 hours, you get sick leave. We don't Now, some of you use the word members. As a side note, you have to scour, we put on presentations, who's a volunteer versus an employee. So you have to get real technical. Here's the problem. Minnesota law is uber liberal on this. If you're, quote, an employee, that means you're employed by an employer, which means you're working for an employer. What does that mean? You're working and getting paid. Generally, if you're working and getting paid, you're an employee. So we can't give targeted advice quite yet, but we will be very detailed who this would apply to. Is we're going to have to scour again, like other laws, who's an employee. So if they're an employee, they're entitled to this, but you're back to, well, yeah, what about our paid on-call ambulance folks? Okay, well, let's do our formal assessment. Normally, I'll be practical, they are employees, but this is just gives you an opportunity to audit who we're defining as employees versus who we can define as a volunteer. Minnesota is very liberal in that, who's an employee versus not. So a lot of folks, bottom line, if they're doing things for you and they're getting paid, much more likely than not, they're going to be employed. But I know we have to do some more of these technical analysis, even for your paid on call firefighters. So, so bottom line, we got a nuance. I want to go back. We're getting a lot of questions on this here, 12 questions. You log in 30 hours, you get 1 hour sick leave. Then you can use that sick leave hour once you've accrued it. Now you're going to say, well, what about payroll purposes? We haven't even had a chance to give them a payroll record that says they get the hour. Here's the deal. We do our look-see on all these laws, but here's the problem. Legislature got a little loose on this because they did not limit, again, in our scouring read of when you can use it. So there is an argument. I've logged in 30 hours. I don't care what payroll says. I've logged in 30. On the 31st hour, I want to work. I've got a cold. I've got a cough. I want out. There is an argument as drafted. They get to use it right away. Now, full circle, we're 90% there, but that is a plausible interpretation of this earned sick and safe leave law. Now, here's why are we taking a deep breath on this one? At least this is 1/1/24, but we get it. Over the summer, we want to update policies, but we can take a deep breath. We got at least a few months and not a matter of weeks before we have to implement this one. But so for those, here's who I think is the wonkiest for if you have a PTO program. It's also wonky with traditional sick leave. Are we going to have a legally entitled sick leave bank and a non-legal sick leave bank? Administratively, that's chaos and doesn't sound good, but here's our concern. We think you might want to do it, especially if you don't like all the usages and also if you lump them together, there's an argument they could sue you if you deny sick leave. So again, things to think about, and we'll give you even more clarity. Now, I did gloss over already the notice that is required. So Minnesota Department of Labor will be preparing a specific notice on notifying employees of the sick leave. Now, I will say this for everybody who's scheduling, we've got an hour and a half. I don't know based on this if we'll get through it, but there's so much. So just, we are going to let the webinar spill over, time permitting, because our approach with this webinar, you can tell, and sometimes how we work it, we're just going to be exhaustive because some of you, for a couple of these laws, you've got like 2 weeks to figure it out. So we're willing to stay overtime as a side note, but let's keep going, but keep the questions coming in. Good stuff. Okay, earned sick and safe leave, a lot to figure out. Just as a side note, Minnesota Department of Labor of Industry may, much more likely than not, will be providing some Q&A on this law. Unfortunately, who knows, might not be till fall. That's going to add a lot more clarity to these technical questions all of you are aptly asking, which you can tell we can't read the legislature's words and say, oh, yeah, here's precisely how some of this will work on a legal bank versus a non-legal bank. So we're giving our best advice right now to help you prepare, but I think you can wait also for DOLE to submit the specific Q&A on some of these technicalities, which they'll likely provide, and or other entities, us included, will provide technical advice. Okay, that was a loaded one. Now we get to, we have a wage disclosure protection law in Minnesota that provides that right now we can't discriminate against employees for asserting their rights. Now, the legislature backdoored the words, which are goofy. I want to first talk about what's the practical effect of how the legislature goofily drafted this law. Here's the deal. We can't force applicants to tell us how much were you paid in the past. As a side note, this is a nationwide trend. So Minnesota caught up, we knew they would, and here it goes effective July 1st. So now here's the nuance of the law. we can't take adverse action or discriminate against somebody. For example, if you ask applicants, how much were you paid? We can't say, well, because you didn't tell us that, we're not going to hire you, or because you were paid too much and we can't likely afford you, we're not going to hire you. You will, that is illegal. Now, the law didn't say you can't ask people for their past salary. Instead, it just said you can't discriminate for, quote, refusing to provide past salary. Let's look at our applications. Here's the deal. I think we have to be careful in applications. So a lot of you will say, how much you were paid at your last job. Then we have a provision at the end says, by the way, excuse me, if you don't, I think we're gonna have to amend application. So what's the easiest route for you? But I don't know if it's gonna be your best practice. Just wiping out asking employees what their past salary was. To the extent your employer and deem that relevant, then you're going to need to carve it out. On one hand, you should, hey, leave in your usual blank, how much were you paid? But then you're going to have to modify things at your application at the end. Usually you'll say, by the way, if you don't give us everything, you might not be considered for employment. You're probably going to have to add a sentence, by the way, if you refuse to provide your past salary information, add this to your sentencing warning, no adverse consequences will be taken against you. So unfortunately, if you're going to ask for it, we're going to have to add some legally nuanced thing in either your Tennyson and or that usual thing you all have at the end that says if you don't give us everything, you might not be considered. So bottom line, yep, it's here's full circle. All public employers on this line are going to have to update their application if you've asked for this. So either it's out or it's in, and we need 2 legal sentences at the end of it that clarifies we're not going to discriminate against you or take adverse action in the employment process if you don't give us that info. But here's the deal. Here's what y'all need to think about. Is this highly relevant now, what someone was paid? Is that even something we should consider? Or if we have it, are we really using it? Or a lot of you are just saying, no, we've got our base pay ranges. Now, applicants can always come to you and say, well, I don't like the idea, but I will say this. A lot of you want to keep it for law enforcement purposes. What do I mean by that? Or other tough to recruit positions. You want to know what the patrol officer you're trying to recruit was made. So here's the deal. I think a lot of you likely are going to keep it in based on, for example, a lot of you with deputies, patrol officers are just having a heck of a time finding them. And to ensure you slot them where they want to be, you should ask for it. But again, we need legal carve out language that says, by the way, we're not going to take adverse action in the employment process against you if you don't give it to us. Okay, so one more thing, we have work to do within 2 weeks. So we will provide specific information. Then they updated nursing mother and pregnant employee discrimination law. We already had the law in the books. Now they've expanded or modified it. First, they talked about employees for post-birth breaks. There was prior to this, you had to work for the employer for 12 months. That's out. So bottom line, from day one, an employee has a right to take certain breaks as already provided under the law. Now, what they do with that is they expanded it and to basically say, oh yeah, you can allow those break times to run concurrently with their otherwise 15 to 20-minute breaks, but they don't have to do it. So you can allow it and say you'll allow it, but you can't require an employee. So what does that mean? For nursing mothers, that they can either run their break with their normal break, or on top of that, they still can have a separate and independent break for that. And then it removed the language before that. Again, I don't even know who really, anybody who exercises as an employer, but whatever, a lot probably in the private sector. Right now, or in current law, you could deny the break if it unduly disrupted operations. Now that's out. Bottom line, they get the break. You can't argue unduly disrupt operations. And right now you already had to require a room, but they just added, which sounds like a best practice anyways. But sure, now they put in the law, has to be clean, private, and secure room. So that's the nursing mother provision. Then we shift to the pregnant employee provision. That modify the current pregnancy discrimination law. So previously we had nuances that certain accommodations required a healthcare note, others did not. But what they did say is even without a healthcare provider saying it, if a pregnant employee says to you, I need more frequent restroom, food, and water breaks, you've got to give it. Before you could nuance say, well, only if your healthcare provider said it. No, now it's just the pregnant employee approaches you and asks for it, they get that. And then it added to the list of other accommodations for employers to consider: temporary leave of absence, modification of work schedules, job assignments, and longer break periods. Thirdly, it requires employers to inform employees of their rights at the time they're hired. So, and when an employee asks about parental leave. So, bottom line, likely Department of Labor of Industry will come up with a sample notice. But here's the deal: you got to do this by July 1st. So, I don't think we can wait. But we are going to have to update now and scramble within a couple of weeks and come up with the right notice to include an express. Now, a lot of you used to notices, but now we just got to be formal with the pregnancy accommodation one and add this to our list of notices. So full circle, I don't think Department of Labor and Industry, unfortunately, will get ahead of it. So we are going to work with public employers to come up with sample text to include in these notices. So we've got nursing mother modifications, pregnant employee modifications. The third hopper related to this is parental leave modifications. So currently, under law, they had to have worked for the employer for 12 months. And they had to be a full-time equivalent employee, and they had to be an employer with 21 or more employees. Now that is out. So the 12-month FTE and working an employer of 21 or more employees, those provisions are out. We now, employers will have to provide parental leave for folks, basically any employee. Now, a lot of you are going to jump in with seasonal temp employees. How much they get could be impacted by that, but bottom line, yep, this law is construed right now as drafted to give them that entitlement. Now, full circle, the leave doesn't have to be paid yet. Now, of course, what's the next slide, and even a future webinar where we'll get into more details, but it won't take effect till 1/1/26. But we have to gap fill here. Full circle, this is still not paid leave time. It's unpaid, but yep, now it's expanded the list of who gets the unpaid leave. And of course, prohibits all type of discrimination of employee requested leave or any other leave under law. So that's the leave hopper. Now, the other one, a little more legal. It just clarifies, for example, if you go to a grievance arbitration on a messy discipline case, we ask for protective orders that preclude the parties from using and disclosing it for certain purposes. So at least expressly does allow arbitrators to do it. Now, of course, we had an arbitration 2 weeks ago. I'm glad we have this law where an arbitrator refused to issue it. Now this law really clarifies no arbitrators. You're going to have to issue the law if it involves non-public data under the Data Practices Act. Now, here's a big one. This is what I call the plaintiff employee gold provision. The legislature in numerous laws added a canned sentence that now expose a lot of you. For all the laws we talked about that were amended, other employment and labor laws, they added a more expansive provision of if an employee asserts their rights, what you can't do with them. That is just, and again, it still has to be a causation thing, meaning the employee will still have to prove, here's the new words, you discharge me, discipline me, penalize me, interfered with me, threaten me, restrain me, coerce me, or otherwise retaliate or discriminate against me because I asserted my right under the parental leave law, because I asserted my right under labor law, because I asserted my right under Minnesota Fair Labor Standards Act. It added to the categories of things you can't do. So I call this, don't be mean to somebody who asserts their rights. I know that sounds flip, but let's be very cautious. Now, we all know what happens. You threaten discharge of somebody, then they assert some legal right that we're talking about. All right, what does this mean? It still means we can take adverse action for what happened with their misconduct before they asserted their right. But yeah, this just adds a second layer of, well, let's be careful and make sure we have good objective evidence when the timing doesn't look good. If we're going to take adverse action for misconduct, but after you threaten it, then they asserted one of these rights. We got to be very careful because it's easy for them to say, well, no, the law expressly says you can't discipline me because I asked. What's a common one? We tell an employee who's not, it's not working out, they can never come back. You know, we have to remove you for non-disciplinary purposes because you've been out for a medical absence for 2 years. Then they say, well, under the ADA, I've got a right to an accommodation, or excuse me, Minnesota FMLA ADA law, and then we discharge them after that. Well, timing looks horrible. and they say you can't discipline me, well, we still have to say, well, we didn't discipline you because of that. So what is this going to do? Let's just be extra cautious when somebody's asserting rights, much like other whistleblower laws, but it just added to the categories you can be sued over and add more liability for you as public employers. Then another good one is, again, a lot of this flowed a little more, I'll be blunt. We're not doing this in the public sector, but okay, good to know. So what do? They ban what's called captive audience meetings. And what does this mean? And again, it happened a lot more in the private sector, bigger corporations. You can't corral employees together and require them to, if you want to talk about religious or political matters. Now, under the First Amendment, we're not doing this anyways, but let's just be careful if we think whatever we're talking about may veer into the realm of what could be construed as politics. Now, how liberally employees may interpret what's a political meeting, that is our concern. You're talking election stuff. You're talking about putting some ballot initiative or referendum or changing your charter. Are they going to construe that as political and you can't require them to come to a meeting to talk about strategy on that? How are you going to put things together? So I get in the public sector, if somebody's cranked up about a position the city's taking and you're having staff meet about it, yeah, I am a little concerned. Are they going to construe this and use that law? You're right. So we're not talking about presidential politics as public employers or usually religious matters and forcing people to show up, but how liberally will that word political be interpreted? So have it on your radar when you're corralling people to talk about what's going to happen, not administratively with public or at the county level, city level with elections, but if you're talking about a specific charter amendment, a referendum, local sales tax stuff, yeah, let's be careful about can they construe it as political and how we're requiring staff to meet and talk about that. So again, you're right. The law defined political matters uber liberally. And when I say liberal, meaning a broad interpretation. Religious matters allows for civil remedies. So let's be careful about required staff meetings and something that may veer into the political realm. Okay, big one. I'm going to do it in 2 slides. Why is that? Effective 1/1/26. We got time. Okay, so this is a big deal. This is a big one. Caught a lot of press. Uber big deal in Minnesota. But then you got to laugh a little bit. Okay, at least they gave us a couple of years, arguably, to sort this out. So paid family and medical leave law. Bottom line, it's going to operate like unemployment insurance program. But unlike unemployment insurance program where payments will come from, it will require you to allow for leave. A lot of you doing this anyways under current Minnesota law and FMLA. So practically, I'll be blunt, it is going to be a cost issue. You're going to have to update policies, but practically, I don't know if this is how much it's going to impact you as public employers on the length of leave or why you're giving folks leave. But bottom line, you're right. It adds a whole big, expansive, nuanced body of law, paid family medical leave with partial wage reimbursement for either a serious health condition or pregnancy or to bond or safety or family care or military member active duty service. Now, again, this warrants and will be addressed in our 4th webinar, the nuances. I'm giving you the high level categories. They get combined 20 weeks for all of this, but 12 weeks for their own serious health condition and all these other things. So there is an argument they could do 12 weeks of one and 8 weeks of another. So full circle, it's not just the 12, it's for the potential combined 20 weeks. They got exceptions, but like, for example, for seasonal employees, unlike these other laws we're talking about, seasonal employees are carved out, talks about what the weekly benefit is. Again, I know there's so much interest, but I'm sorry, it's 1/1/26 and be covered in the 4th webinar, be funded by a payroll tax. So the bottom line, the state will provide the partial wage reimbursement. A lot of you are going to have to work on laws because you can supplement it. A lot of you will likely do that or allow them to use other paid leave, much more likely than not is what a lot of you do. So a lot of this is going to be sorted out, but yeah, good to know. Let's spend the next year-ish or so to get our policies up to date. So at least you got some time. Now, of course, marijuana, big deal in this session, which of course impacts all of you, maybe not just practically or personally, but let's get to the employment end. What's our deal? They did take all the cannabis laws and say, okay, well, we better catch up a little bit with employment laws. And the one they did catch up with is Drug and Alcohol Testing in the Workplace Act. So, I mean, this is, they spent a lot of words to say a simple thing. is cannabis is still a drug under the act. However, they did add cannabis testing as a separate way to test folks. So what do we really mean by that? Let's get into the two sub-bullet points. One, you're prohibited from conducting pre-employment or random testing for cannabis in most circumstances. So they did clarify that. But for safety sensitive positions, and again, it talked about your usual folks, your safety sensitive, your peace officers, firefighters. Now, just so you know, where I still want to be clear, this law is still independent of federal CDL law. This is just when we're applying our non-CDL drug and alcohol testing, here's what to do with it. We still can require it for gobs of people who we're still have concern about if they're under the influence of cannabis. So what do we mean by that? We still can test it. We can't do pre-employment. We can't do random. However, we still can test it, much like alcohol, for these other safety sensitive positions and even other positions. And they talk about we still can test it like any other drug. So I'm sorry, there's a little bit convoluted explanation, but bottom line, here's what we need to do. Again, instead of listening in a webinar passively, let's dust off our drug and alcohol test in the Workplace Act policy. We need to look at the policy and apply these cannabis provisions in the new policy. So mechanically, that's what all you should do. That's going to force you to know this law better than articulated in the slide. And can I go backwards? Someone talked about sick time for care of others. Is the law is very specific. I'm not going to go back to that slide maybe right now. Back to the earned sick and safe leave time, I think the question was for, or even under the new paid family. The law is very technical on how a family member is defined. So again, go back to that law, which had a liberal interpretation of what that means. So I think the law was clear on that, but we can go back to that specific slide maybe as a follow-up to the webinar that we can definitely do that. So back to this one, cannabis, we got updating to do. So you are going to know this better again when you update and draft your drug and alcohol test policy. All right. Now we're getting there. Oy. Next one's thankfully you can just sit back a little bit. Yep, you'll have to comply and know about it, but it's not as meaty as all these loaded ones we just went through. Under the Minnesota Fair Labor Standards Act, as a side note, they increased fines for employers that if you screw up Minnesota Fair Labor Standards Act, increased fines to $10,000 for each failure to submit or deliver records as required by DOLE. So how does this happen? If there's a claim from non-public safety who's not subject to Minnesota Fair Labor Standards Act, any other employees, a lot are, public works employees, whatever. If there's a complaint and DOLE says, hey, public employer, which has happened with our cities and counties, et cetera, hand over certain records so we can see if you comply with the law. If we don't do it, which you won't now based on this, you could be fined for each $10,000 for each time you don't do it. So I got to tell you, our public employers, when DOLE asks for stuff, we're giving it to them. So, but good to know. Now, another one takes effect 1/1/24. If you have 50 full-time equivalent employees or more, which means you cobble up all the hours of what folks worked, you have to post a poster, which just as a side note, just take the one DOLE, Department of Labor Industry, will create, and they'll create that. Who cares? Don't even change it. Just take what you do like other posters. If you have that many employees, it'll talk about veteran benefits and services, and you just have to post that one much like any other. So bottom line, all this would do is add one more poster to the bulletin board. Wait till DOLE does it, print it off, post it. So we really don't have much more to say about that one than just do what DOLE says, print it off and post. Of course, Juneteenth, all of you know, in fact, at the last minute, we're just an absolute Juneteenth scramble. Since the legislature in May decided to fix the law they adopted in February to make Juneteenth a state holiday. Now, obviously, we have a lot of questions that the legislature didn't clarify its independence interpreting. They did say this, so let's break it down. 3 things apply. Everything else is up to your discretion. It just says no public business shall be transacted on June 19th, which is in 4 days. On June 19th, except in case of necessity. Now, I will say this. We have had gobs of questions, well, do we have to pay people? Nope, Law's silent on that. Do we have to say employees don't work or shut facilities? Nope, the law doesn't expressly say that. The law only says this: you can't conduct public business except in case of necessity. So we've been sending out technical advice. Well, what does public business mean? Does keeping our community center open, is that public business? Maybe not. Or even if it were, what do we deem as a necessity? Now, where's the necessity one? Clearly, you got to have law enforcement up and running. So, and then we have all these other carve outs of what things do we need to do? Here's what is clear in all the mushy advice we've had to give, because the law is mushy. Attorney General opinions interpreting it as mushy, is getting in the weeds of what public business are. So here's the deal. 90% of you on this have probably figured this out since you only had 4 days to do it. But we still at the last minute, we're having councils and governing bodies draft resolutions. We're still drafting to this morning memorandums agreements that the unions are adopting. So we get it. A lot of you in the last minute scramble, but a lot of you had figured it out. So there's Juneteenth. That's sort of old news. And somebody just asked that question. Municipal liquor stores, again, city attorney listservs had a lot of discussions on that with the mixed results. There is a specific AG opinion on that, which I'm sorry, at the top of my head, I forgot which way it went. So we can follow up with that one. Again, I already articulated, well, pool, summer baseball, there's an argument, is that really public business? That's operations, but is that business? There's a plausible argument, it's not public business. So here's the deal. I don't want on the webinar say precisely what you can have open or not. I think that's very targeted. So if you got follow-ups, and we have dealt with a lot of these nuances, ask us and be technical on, all right, what facility, what programs are we talking about are or not public business? There is an argument public business is liberal, but there is an argument you can argue a lot of things are necessity. Of course, even in Minnesota, selling booze. But there's a specific AG opinion on municipal liquor stores. So off the top of my head, I don't recall that one. That veers a little bit from employment, though it impacts employees. So full circle, we get it. We'll be drafting legal opinions on Juneteenth till June 18th at 11:59 p.m. But what was my goal on this? All right, you all know the drill. Took effect for 2023. So another law, I know it's meaty, but it's going to be addressed in our 4th webinar on when we're going to get way in the weeds on this one. Talks about treatment for mental injuries, keeping injured employees on payroll when they have an injury. A lot of this, League of Minnesota Cities put out some good guidance. CGMC's been involved with this, Association of Minnesota Counties, et cetera. So what's the gist of the law? You're going to have a lot more to do when someone claims mental injury who's either a law enforcement officer or firefighter. So those are the first 2 bullets. But again, I know you got to scramble a little bit, but it's only likely going to apply to new cases. So brace yourself. We're going to get in the weeds on this in 1 week. I know timing's short. Then, of course, the big one is there'll be full reimbursement employers for the cost of continued health insurance for disabled employees. So for a lot of you, we challenge duty disability cases because we're on the hook for paying people. That does not change. So as a public employer, 4th bullet point, you're still going to have to cover and pay your contribution for health insurance until 65 for employees who are deemed duty disabled. But then the legislature said, well, for now, it will fund it and put it in the law, will fully reimburse you. So funding's there for now. The law is there for now that says you get full reimbursement. But we're talking with a lot of public employers on, okay, which is a mixed result. Do we roll the dice and hope the legislature will do this for the next 20 years, that officer or deputy or firefighter X will be covered and we have to pay health insurance? Some are saying, yeah, forget it. We hope they do it. Others are saying, well, that's too risky. Let's still fight. So we're having a lot of those nuanced discussion with public employers. So that's the 4th bullet point. Then it talks about you got to have learning objectives in place to get full reimbursement on how to handle traumatic events, which you should anyways, but now it's mandated to get full reimbursement, and clarifies that certain recipients will have to reapply each year for the first 5 years to prove up they're still duty disabled. So the moment they're not duty disabled, even if they initially were, then they're going to have to reapply every single year with certifications that they are still duty disabled. Then if the PRA says they're not, then the requirement to cover them and or pay for them would be relinquished. So they at least tighten up that law. I know a lot had opinions, a lot of work went into that, but there's where we are. Another one was the known as the Crown Act that talked about, we can't discriminate, employees based on race, and it clarified what part of what race meant. So the bottom line is traits associated with race, including but not hair texture, hairstyles, braids, locks, and twists. So looking at questions. So bottom line, that just clarifies that we can't discriminate based on that. So I know we have 9 minutes left, but like I said, I'm willing to spill over past the half hour, even though I got to tell you, some of you probably had enough anyways and will listen to the recording at 11:30 based on the employment law palooza, but we'll talk about recommendations on the end. You may want to stick around for that. So if that weren't enough, though the Congress is split, we still have an administration who can do things unilaterally. So a lot of the law that's going to happen with National Labor Relations Board, to clarify, that is only for private sector, but we talk about just about every webinar. Decisions made by National Labor Relations Board, which is now set up like our new PERB board, a lot of those decisions are going to be persuasive for how PERB is going to rule on things. So whatever NLRB is doing at a federal level is clearly going to impact what's happening with PERB and unfair labor practice claims. So what are we going to have to do? Again, National Labor Relations Board and its law, it's just a political football. All it depends on, do you have a Democrat or Republican president? And decisions are automatically, where decisions are going to go. So what are we back to now under Biden administration? Your personnel policies, especially like respectful workplace ones, are now going to be re-subject likely, assuming NLRB law will change. Their advice is already changing and decisions are changing, likely will impact the PERB board. They're not going to like provisions that say don't complain about your employer. So we're back to, again, whole nother webinar that we may likely give once PERB is up and running, but we are concerned about your catch-all provisions. Don't complain in the workplace. Well, we can't have those. You have one of those. Now NLRB law, persuasive of the PERB, is likely going to say, no, you can't have those anti-complaint provisions. You got to be a lot more narrow and targeted. Who can't do it? What can't they do? What are the circumstances? So bottom line, we're going to have to be a lot more targeted, likely, in our respectful workplace policies. There's also going to be a lot more challenges to employer surveillance, IS surveilling emails, security cameras you have in the liquor store, using that for potential discipline against employees. There's going to be, now, we give targeted advice. We give a lot of advice, security cameras, even outside your government administration building. Bottom line, there's going to be your GPS that you place in squad cars to assess where law enforcement officers are going, using that specifically for employment purposes. We're going to have a lot more scrutiny. Concerted activity relates to the first one. Employees likely will be a lot more able to collude and complain, and it's going to be a little more difficult for us to either take adverse action or limit that. So again, I know that a lot of this is high level, but I think you all get the gist. Let's look at our policies and how we're enforcing it. We already have Minnesota law, and I think employers may be teed up if we don't comply with the new law. Union access to business, in their case, business in the private sector, employer facilities, and specifically emails. Well, the legislature just cemented that. So we all know we got to game up and give them more access to emails, give them more access to our facilities. Another one they just kibosh, which is causing la land for us, but I do think, unfortunately, we may see a PERB decision out of this. Generally, when you have an employee separated under bad terms, you have an agreement. Part of the agreement is, well, neither side's going to disparage each other. I will say this, oftentimes the employer and employee like that. Yeah, it's limited in the public sector. We got First Amendment rights, data practices issues. We, as you all know, who we've gone through this rodeo with, we got to be very careful how we draft that anyways. Here's the bottom line. NLRB said, no, those are done. So now that's a very high generalization, but that's what they said. They kiboshed a separation release agreement that had confidentiality. We have to be careful of those in Minnesota anyways, and non-disparagement clauses. So I am concerned where those are going to go. What can't we give legal advice on? Because this law is not directly precedential with Minnesota's public sector, we can't say it's illegal to have these provisions. We can't say that. Might it get there? Maybe. What do you need to do? You're doing separation release agreements. Talk to us. We'll work through with this. We may stick with our canned language, roll the dice. We may modify it and get more conservative. But let's see where PERB might go with it. But for now, this law is only likely something that's going to pop up with PERB, but it's not the law in Minnesota yet that those are prohibited. Now that's NLRB. And see, I did this from not a court level, but an agency level, which impacts what happens in the court. So I thought this was a good way to structure it, especially you're all probably exhausted after the state law one. So, we heard a presentation in May in Minnesota from legal counsel for EOC. What do they say? What are the 5 things they said? All right, here's what we're focused on. So good to know. 1, disability accommodations. It's not just what accommodations are you giving? Are you engaging in the process, which we've gone through a lot of you with fitness for duty. Engage in that process and you're probably going to be okay, even if the end result is no accommodation or something the employee didn't like. You will get in trouble if we don't engage in the process. So the moment someone says, I've got an illness or injury, I need an accommodation, let's work on the process to see if they're disabled. If they are, let's exhaustively exhaust the reasonable accommodation process. So practically our advice isn't changing, but good for all of you to know it's going to be more on the radar for EOC. What does that mean? A lot more of you may be subject to complaints made by employees to the EOC, or their law impacts what happens with our Minnesota Department of Human Rights. Secondly, artificial intelligence impact on hiring process. What do we mean by that? We hear a lot of AI in the employment world right now. So some of us go back and go, even though it's off, we just picture ET, but no, obviously we're talking about computer, electronics, et cetera, artificial intelligence. They're really focused on application stuff, your automated application tool that weeds people out based on specific criteria. Now, of course, what are they suing and what employers are losing? The people who are weeding out, literally, you had private sector employers weeding people out based on a gender or age. Okay, none of us are doing that. But okay, let's not take that. All right, well, good. As long as we're not doing that, which we never would anyways, we're in good shape. There may be other discrimination things you're set up for in your hiring process that you don't realize on its face are discriminating based on race, are discriminating based on age, are discriminating based on familial status. So let's just be careful. Let's do our usual discrimination audit in your screening tools you're utilizing in the hiring process that may be automated. Let's do our audit to make sure we don't have a discrimination problem with those. Pregnancy accommodations, obviously in Minnesota, we have specific Minnesota laws that doesn't impact this, but there are federal pregnancy accommodation laws that aren't quite as detailed as ours. But why am we saying this? This is what EOC said is one of their top 5 priorities. 4th one, now thankfully under Minnesota's rigid pay equity law that just about all you in this webinar are subject to, we're going to be okay here, though you still could be teed up. Pay discrimination law, especially based on gender or race. So where are we seeing this? And we have had complaints gone to the EOC based on this. You have a nice base pay structure. You have points that dictate based on job class what pay is, and rigidly your structures are good. We're compliant with pay equity law. You can't, Minnesota is the most rigid pay equity public sector law in the country, so you're good on that. Where could you get dinged is placing, for example, let's just take a black and white example, placing a male deputy sheriff who just started at a higher step within your scale than a female deputy sheriff who just started. So that's not illegal. That's fair. Where are you going to be scrutinized is let's make sure we have documentation why we place each employee, for example, at a higher step than if you, for those who have steps or somewhere higher in your range even, then especially if you have a gender or racial differences in who you brought on, why certain people were placed higher than either the start or step 1 of the scale. So that's something to have on your radar. And then the 5th priority they articulated was LGBTQ issues. Again, all this is employment, meaning let's be careful about discriminating based on that. So for those who thought the cutoff was 11:30, we won't be offended if you need to lop off, but We had so much to talk through. I'll just keep going through the presentation. And again, for those who have to lop off now, obviously we'll provide a recording of this webinar and also provide the slides for how to utilize as a tool. For those sticking around, let's keep going with federal issues. Now we get U.S. Department of Labor. They got two main things on the agenda. One, to increase the salary for exempt employees. What do we mean by that? That right now you have to meet to be exempt and not subject to minimum wage or overtime or record keeping laws under the Fair Labor Standard Act. There are two tests. One is the duties test. You basically have to be higher level, but there is a low salary bar. The salary test is low. So you get your foot in the door with paying somebody $35,000 to say they meet the salary test to be exempt. Much like the Biden administration who didn't, Obama administration didn't get far with this. The Biden administration really wants to push this, but they've hit some political snags to raise how much an employee would have to be paid to meet the salary test. So that means if they raise it, let's say hypothetically to $80,000, right now you have people who might be exempt in the $35,000 to $80,000 range. Just, they likely wouldn't go that high, but just for the sake of argument, we now can't deem those people exempt because they wouldn't meet the salary test, even if they met the duties test. So wherever it goes, it may winnow down the number, for example, of middle management employees you have who are otherwise exempt, now might not be. So bottom line though, this regulation is not in effect and likely will be, or at least they're pushing it, though they've hit clear political snags from the business sector. Then, of course, much like NLRB, they want to, and NLRB, I didn't catch up with my presentation, put out a decision 1 or 2 days ago that narrowed the definition of who's an independent contractor. What's the gist of this? We've talked about this in another presentation for years. This means a lot more people who deemed employees who are otherwise deemed independent contractors that were outside the city, so, or county, or other local government. All right, so we got NLRB, EOC, and U.S. Department of Labor. Then the fourth main federal agency, what has been their priorities? Again, priorities matter because that means they'll be doing it, and they already are. OSHA, so safety stuff in the workplace. What are 4 of their main priorities? Strengthening enforcement. Okay, well, the law, they didn't change the law on this, substantively, what you need to do to have a safe workplace. What they did say is, we can and will get more aggressive in inspections. We can and will get more aggressive in citing folks. We can and get more aggressive in forcing you as employers to give stuff. So that's strengthening enforcement. Targeting high-risk industries, a lot of you are not, but those in the municipal electrical world, you are. So you may be targeted. 3, emphasizing prevention. So making sure injuries don't happen in the first place and forcing you to ensure you identify and address those. And 4, better data collection, so they can monitor what are the workplace injuries and illnesses. So I think the biggest one for all you is strengthening enforcement. Watch out, they may be coming more. Obviously, we have Minnesota's version. Minnesota adopts the federal laws, so full circle, this will have an impact on Minnesota. 5th thing is, this is so cross-agency, I did not identify specific federal agency, but here's the deal. A lot of it will be U.S. Department of Labor, a lot of it will be EOC, a lot of it will be OSHA, is a lot of you are allowing more post-COVID folks are working remote. What are we seeing already? A lot of litigation over, well, hang on. Employee X working remote was spending a lot of money to do the work of the public employer on their own. And a lot of debate is, well, should you be reimbursing that employee for that? 2 is workplace injuries. What happens if they flop over on their chair while working for you? Okay, well, that could become not only a workers' comp issue, but an OSHA issue. 3 is workplace accommodations. What do I mean by that? Not people existing, already working remote. A lot of litigation, I think, will come from, and we dealt with this a lot during COVID, but there's been a whipsaw effect. Well, I am having surgery. I've been working in the office. I'm middle management. While I'm recovering from my knee surgery, I do want to work from home because I can't move, which means I can't show up in the workplace, but I can work 8 hours a day from the government issued laptop. So accommodate me, allow me to work remotely. So I think you're going to see a lot more litigation, a lot more scrutiny of, well, you should add that to the hopper of accommodations, and you might have to accommodate a lot more than you otherwise would. And maybe even it's full-time remote work. So full circle, a lot more coming up on that. What's again the gist? You think the lawyer always says it? Yeah, it's probably true, but let's update our policies. Let's update our procedures and practices, how we accommodate remote work. Okay, we got state law, we got federal issues. Now, in one slide, thankfully, is what are, I'm distilling without our nice usual stats because it's reality and I think good enough for one slide. What are we seeing a lot of? Now, we can't say different. Some of these are, some of these are not. But what are the hot labor contract grievance arbitrations? And again, this is based on BMS data. So let's distill for them. One, of course, you can employees. Well, I think that one will always be there, so I don't know if that's new news. Two is premium pay, though, in that you have employees are saying at the bargaining table, I want more money, more spiffs. And also the unions, especially public safety and public works, are getting a lot more aggressive on asking, saying under the current contract, we're entitled to premium pay to a lot more circumstances than use the public employers otherwise we're paying it for. So I got to tell you, we're dealing with gobs of that for public employers at the front end. But on the back end too, we're seeing these go all the way to arbitration because unions are cranked up about it. One, when, for example, working on a holiday, when do you get it versus when do you don't? Another example is when do I get time off or not? I think just, for those who didn't update their contracts, which was fair to update Juneteenth, we're going to see grievances on that where unions claim entitlement where the contract didn't say it. So let's look at your language. Callback pay. You called me in, what's a callback? Is it extension of a shift? Where are we seeing them as well, grievances? Well, I was at home drinking in my cabin on July 4th. You called me. I spent a half hour on the phone directing somebody to do what to do at the wastewater treatment plant. Then they say, well, it's not just, all right, everybody agrees. Yeah, you get half hour pay. Yep, you spent time, you worked for us. They're saying, well, no, that's a callback. I understand I was on, sitting on the beach and talking on my cell phone, but that's callback pay where I get a lot of you have minimum 2 hours of time and a half. We're seeing more of those. Overtime. What exactly constitutes overtime pay under the contract when you have loose ones like extension of shift or when you work something other than your shift? A lot of what we see in our arbitrations are, well, you change my shift. So let's take an easy example. Taking a law enforcement officer change their workday that they otherwise scheduled for Monday the 20th, and you flip it and say in the schedule, you tell them a month in advance, you're actually going to work June 21st, not June 20th. Then they say, well, that's not my regular scheduled shift. Give me overtime. So we're seeing more of those. Assignment pay is what somebody's doing a higher level pay that warrants. A lot of you have what's called all the class pay that basically says, well, if you do higher level duties, you get that extra pay in the contract, time and a half. So there's a lot more debate of what constitutes higher level duties. Here's what we see in law enforcement is I'm a deputy sheriff. The chief deputy sheriff was out. I had to do a lot more administrative or management stuff, pay up. So we're seeing a lot more of that in the assignment world. Third thing, appointment, promotions, and assignments. A lot of employees claiming I was entitled to get that appointment, or a lot of it is I was entitled to that internal promotion. Here's where our black and white arguments are coming. It's in arbitrations. And a lot of you are hiring folks maybe with 5 years of experience or 7. There's more grievances on the employee who've been there 10 to 15 years, but let's face it, they had a real bad record and claiming, well, I'm entitled to promotions based on the contract provision that says you have to take the most qualified. Okay, so we are dealing with more of those. Now, our best advice, some of you are saying, well, too late. Don't have anything about promotions in your contract, literally nothing. Then you're in good shape. You'll never lose a grievance. You're in bad shape if you have promotion language and it talks about who gets promoted, which the bulk of you do. So I get you're stuck with it. Try to get rid of it. Good luck, but keep it out if you don't have it. Work schedules, changing the work schedule. Who gets on what schedule and claiming entitlement by seniority. So that's another fourth trending topic. Again, some of these aren't new, some are, but just to have on your radar for those who have unions. So finally, conclusion. All right, how can I conclude it? Y'all got a lot of work to do, and we all got a lot of work to do even before July 1st. So what do I mean by work? Here's the deal. Let's look at our policies especially. And some of you have, procedures and practices, but I'm really focused on policies, what you have formally in writing. Based on all this, based on new labor laws, even the employment laws, what are we going to have to do a peek-see at? Respectful workplace policy. That's a big one. Are we too liberal and broad in that? 2, Leaves. Obviously, we've got new leave laws. We all know we got to look at our sick leave and PTO policies. Everyone on this call is going to have to look at those and determine how are we going to comply with that and apply the new law, which we will get real technical on. Reasonable accommodations. Let's make sure we've got a fair process that's not too rigid, and let's follow it as well. 4, access to government real property. Let's make sure we don't have a union prohibition, which none of you do, but some might, which did happen in the private sector. Let's make sure the union can't argue, well, you overly constrict our access to real property. Even if you do, make sure to tell the unions, yeah, you get a, carve out, especially even on the next one, use of government equipment and technology. Let's make sure we have a good policy that says you got to use it for work, and your personal, even union stuff, only can be incidental. But recognize reality. None of you can have a provision effectively apply that says you can never use it, because there is incidental stuff. So we got to balance practical reality. Workplace monitoring and security. Let's make sure that employees or unions can't claim, well, you're doing too much to invade my privacy. Have a good policy. Here's the deal. You can get away with that as long as you have a good policy that told employees what you're using that camera for, what you're using the GPS for, what you're using email surveillance for. Obviously, data practices, record stuff, holidays, Juneteenth, pay plans. Let's make sure we got neutral stuff and apply it on how we're slotting employees in our stepper ranges. Safety issues, obviously, get those safety committees up and functioning. Update that safety manual. Now, substantively, I can't tell you based on this, you have a lot to go with, but we do know OSHA is going to be much more scrutinizing likely, either your preventative measures and or if you get an injury, what happened. So update those remote work policies. A lot of you went ad nauseum through that for COVID. So you got infrastructure, but let's update it based on that. Make sure we got accommodation provisions. Make sure we have reimbursement provisions. Make sure we clarify who gets it, who doesn't. That's a big deal. But leave yourself discretion as well. Obviously, for cannabis, we know we have to update within 2 weeks our drug and alcohol testing policy to address cannabis. Beyond policies, obviously, a lot, for example, with the union stuff, requires you to be automated, requires you to have a systematic Excel file. So, regardless of your HRS format, unless the union agrees, set up your Excel files. How are you going to get, in what precise format will you be giving the unions all that stuff they're entitled to with new hires every 120 days for current employees? So beyond checklist and forms, also develop form letters, for example, for accommodations, have checklists on how to comply with all these laws, especially on the union provision of data items that you have to give them on employees. One thing that can help you with avoiding like a new unfair labor practice, avoiding a concern that you overly inhibited employees to complain or express their grief in the workplace. If you're just gonna have to be more in tune with employees who claim, especially if they think they're the victim of something, and especially with all these discrimination laws. Promptly communicate with them, get a strategy right away, working with legal counsel, working with HR, and investigate them. I think a lot of you are going to have to ramp up what you're looking into. I don't think we can be as dismissive with employees. For example, with that liberalized law or words that we see in all these laws on parental leave, union stuff, pay stuff, employees generally have a lot more right to complain without employers taking adverse action. But let's be positive and let's take those a lot more seriously, probably than we did on some of them. And let's look into those a lot more. So welcome to more gainful employment for lawyers and HR, but I think that's reality. 3, let's make sure we know what the interactive process is. So somebody says, I've got an illness or injury, let's get more aggressive. You're not conceding there's a disability, you're not conceding you have to accommodate, but let's move a lot more quickly and not as dismissive, even if we think the illness or injury is minor, because EOC has already said, we are going to look a lot more at you to make sure you engage in that interactive process with someone said something that may be a disability that limits them in the workplace. So get a lot more aggressive in the accommodation process. Do a workplace safety audit, like we talked about, with your committee, with your manuals. Now, I know the last one sounds a little squashy, but I think this is a reality. How can you mitigate folks, now again, more lawyer talk, from either wanting to pursue a legal claim or being successful? Build a culture of communication and collaboration. That's going to help you in the labor realm. That's going to help you in the employment realm. And I'm not just saying just do it. Have it in your policies. Have it in your goals. Have it in your missions. have it in your budgeting process, have it in your staff memos, have it in your discussion with your governing bodies. You got to start using those words a lot more. And of course, obviously do it, but let's use that word choice that maybe a lot of us maybe aren't quite using that as much. And provide wellness and other employee support programs. Obviously, for example, technically, that's going to help you with administering the new duty disability updates and working with law or public safety who has certain mental injuries. So if you don't have a wellness program, look into it. Or again, spruce up your employment assistance program. Either get one if you don't, most of you do, but let's make sure we're, one, not only have it, two, we know how it works, three, we're effectively communicating it, promoting it for employees. So there we go. Not too bad, only 15 minutes overtime, but I had about 6 questions. Some of you maybe came on late. We will provide this webinar and post it online, not only the recording itself, but also you'll be able to see the slide. So yes, that is forthcoming. So I will take a quick timeout if anybody has any questions or answers, but for even those who don't have it on webinars, I know we're still working with a lot of you on how to implement all this, especially the Juneteenth scramble. So I do have one that came in. Somebody asked where the video gets posted. It will be on the CGMC website, and we will be submitting communication to all participants where it'll be posted. So we will give you the specific link where that's at. So absent seeing any other questions, I just got 1 minute dust up. What's coming next for our webinars? The 4th and 5th. 1, work-related injury and duty disability landscape. You're going to hear a lot more about the new PRA duty disability law. You're going to hear more about paid family and medical leave and even earned sick and safe time, even some of those dust up things with earned sick and safe time that you could tell based on this presentation, we're not quite there. The legislature was loose, so we are going to fine tune our advice, for example, in that. Then the last one will be public employer workforce and compensation tools. How can we make sure we can effectively recruit, retain, and motivate employees in the workplace? And we've already addressed some of that legally. So those are coming up. Those are in the same canned email that you got with all the other webinars to sign up. Feel free to contact me or any other member of Team Labor, our attorneys, our analysts, our administrative assistants in our office to deal with this plethora of issues that you're on the clock and you've got 2 weeks to figure some of them out. So we appreciate it. We hope you found this a good tool. We enjoyed doing it. I apologize for going overtime, but hey, that's what the Minnesota legislature gave us. So we want to be very specific and very detailed and try to cover just about everything they adopted employment-wise. So again, thanks to all of you, and we hope we will hear from you, and I'm sure we will hear from a lot of you. So thank you.